review or?
Yeah. All right, well, let's get started. I'm attorney Peter Harbach, and this is attorney Sarah Kahns. We're a couple of the estate planning attorneys at Hooper Law Office, and thanks for joining our session. Today's going to be talking about what's a will and how does that work, what's a trust and how do those work. So hopefully you find this useful. This has been an ongoing series we've been doing in kind of response to some of the quarantine and COVID and whatnot. So our next session is going to be next week, the 24th at noon. So if you find this one useful and you want to continue, noon next week as well. This is an ongoing series. So anybody who's registered, you should be receiving a couple of things. Primarily, we've got a wills and trusts comparison sheet that lays out how each of them operate. And then in addition, there's also a diagnosing an estate plan, which kind of lays out some of the things that people need to look at to determine whether or not they might have an issue with their estate plan. Unfortunately, a lot of estate planning stuff is not common knowledge, but it frankly has an enormous effect on everybody and everybody's families, because the old adage of the only thing that's certain in life is death and taxes. If you own anything, that is your estate. Estates aren't necessarily Bill Gates sized wealth or anything. An estate is just frankly anything that you might have ownership over when you pass away. And so that represents everything that you've ever accumulated in your lifetime. And so with a little bit of proper planning, you can make sure that you minimize those taxes and pass it on in such a way that your beneficiaries' individual circumstances are accounted for, and that they're taken care of in a manner that you would have wanted to provide for them, and that everybody gets the right amounts that you intended, because I'm sure you would agree that unintended consequences of not understanding how their plan actually works can really cause a lot of problems within the family after somebody passes away.
Expectations, managing expectations are always, I think, a big part of an estate plan being successful. We have obviously a lot of different tools at our disposal whenever we're creating a plan for someone, and ensuring that the people that you're including in your plan understand what tools you're actually using really allow you to, I think, do a better job of making sure that there aren't surprises, or that the expectations that people have are dealt with in a way that it helps to bring the family together. Managing expectations as part of your estate plan is really what can lead to a much more harmonious settlement process or administration of your estate. Surprises, I think, are always the thing that hurts the most.
Yeah. In line with the title of our program, we're going to talk about what in the heck is a will. We should also mention, because I failed to right at the start, if anybody has questions, we're going to take some time and answer any questions that get posed to us at the end. So feel free to type them in if you're registered through Zoom. We'll be able to see those in the future. If you're just live streaming this on Facebook, probably better to register through Zoom, because then you can A, get the materials, but then B, easier to participate and get any questions you might have answered. So what in the heck is a will? Simple definition is a will is a set of instructions for the probate court. So a lot of people think, hey, if I have a will, that means my family's not going to be in the court system, right? Because I say where the stuff goes. But that's not how this works. A will literally is instructions to the probate court. But one of the biggest problems that we run into is that people don't understand that means the assets have to go through the probate court in order to be governed by the terms of the will. So any thoughts on why that might be a problem?
I mean, it's always a surprise for people that, well, I have a will, so it just applies to everything I own, because that's the purpose of my will. It's to direct where my stuff goes after I've passed away. But because the will is specifically for the probate process, if you're not having your assets funneling through probate, then your will doesn't apply to everything that you own. And that's where we see a lot of disjointed planning or unintended consequences. So with the will being a set of instructions, you want those instructions to apply to the stuff that you have. But what we see a lot of when we're reviewing current estate plans or asking what people have done when they come in to see us are a lot of people that have created a will because, everybody needs a will, right? So everybody does a will. But then we see a lot of designating of assets because, well, I don't want my assets to go through probate. Even though I have a will, I want to avoid probate. So we see designations, and that's where you start to see the sort of contradiction or conflict between what you have written in your will and what you're actually doing with the things that you own.
So here's a concrete example, one that we've had happen so many times, innumerable times. Somebody creates a will, and because they have certain things that they might be concerned with regarding their family and the passing of the assets after they die. And then they find out, oh yeah, I don't want this account to go through probate. So their banker says, oh yeah, just put a POD, like a payable on death designation. Well, because that then avoids probate. So hey, that's good, right? Not necessarily, because probate, yes, avoiding probate can be an opportunity or an objective in somebody's estate planning, but it also means that person has avoided all of the planning they've done in their will by having this POD designation or beneficiary designation on the account. So when the asset passes, the person often thinks, oh yeah, I took care of everything I wanted because I have these terms in my will. And so that's going to make sure that the family's taken care of correctly. Not realizing that it's not the will that's passing the asset then, it's the beneficiary designation that's passing the asset. And so they get this disjointed estate plan that has unmet expectations, and the person often passes away ignorant of the fact that they're creating a big problem for the family because they thought they took care of the problem with the will, not realizing that, wait a minute, now my assets aren't using the tool that I intended to. So just because you took care of something in a will doesn't mean that that's going to happen with that something. It's only if the assets pass through the probate process that those assets are going to use the terms that you bothered to put together in that will. So it's impossible to just overstate the importance of understanding this. If you create a tool, whether it's a will or a trust or put things in a marital property agreement or anything else, you have to make sure you're using that tool, or it was a waste of your time to create the thing to begin with.
Joint ownership is another example of this, where, especially as people get older, well, I want my child or my loved one to be able to write checks on my account or take care of my bills, or I want them to be able to pay for my funeral using this account. So rather than having them be like a power of attorney agent or something like that, they take them to the bank and they put them on the account as a joint owner with them. And joint ownership with accounts or with property even, the way that it works in most circumstances is when one of you passes, the other one just now continues to own it alone. So it's not going to pass by the terms of your will. It's not going to go by your estate plan. It's not going to be divided among anybody. It is going to be owned by the person that is also on this account. So if you intended that to go to maybe your 3 or 4 children, even if the person that you're putting on as a joint owner wants to do that and intends to do that for you, there can be legal reasons why that person isn't allowed to do it, even if that's what their expectation is or that's what they want to do.
Because they can take the money and run.
But
even if they don't want to, like you were saying, there can be legal prohibitions because now this person is making a gift because they received it in the joint ownership. And now there's no legal obligation that they share it. So their decision to is a gift. And that's a big problem in a lot of circumstances.
So the point in all of this is you want to make sure that the tool that you choose to use is used by what you have, that you're not creating a document using and setting up a will, or we're going to talk in a minute about trusts, setting up a trust, but then having your assets be directed elsewhere or using other types of passing, because you set up this plan for a reason, right? You want your family to be able to benefit from, okay, I'm just following these instructions. I'm not making decisions after you're gone. I'm just, these are the instructions that my loved one left. This is where they intend their stuff to go. And because all of their stuff is being governed by this document and by this plan, I am just following through with what it is that they laid out. I mean, some of the most difficult positions for loved ones to be in is making decisions for you after you're gone, especially when we're working with children. When a parent has passed away, your kids can accept decisions from you. It is much more difficult for them to accept decisions from each other about what happens with your stuff. So, and these people are also going to be grieving at this time, and there might be, other family members that get involved. And what you want them, the person you put in charge of this, to be able to do is say, okay, here are the instructions. My job is to just pay the bills that I need to pay. And then it gets divided by these terms. And all they're doing is following through with that. That is putting them in the absolute best position you can possibly put them in.
I'm trying to keep family harmony that way.
Yeah. As much as possible. You want your estate plan to bring people together and get them through a difficult time, not create division or conflict at that point.
Yeah. One other bit of advice on this is, do not take advice on putting beneficiary designations, payable on death designations, TOD designations, which is transfer on death, or joint ownership on any kinds of accounts or property, unless the person providing that advice fully understands your estate plan, your will, or your trust. Because if they've never even read the thing, they can't possibly be giving you good advice on how this thing is going to play out after you pass away. And the repercussions are huge. So just make absolutely sure that you're not taking advice from somebody who has not reviewed your estate plan. So if your banker is saying, hey, own this jointly with your child, or put a POD designation on it because that'll be so easy. If they've never read your estate plan, they can't possibly know if they're giving you good advice or not. And again, the repercussions can be very detrimental to your family. So it all has to be taken into account together.
All right, so we should probably talk a little bit more about trusts. I mean, all of these things that we're talking about concerning passing assets and using your plan and making sure that your documents and designations are coordinated with your plan applies just as much to trusts as it does to wills.
Absolutely.
Just like if you have a will, you want your assets to go through probate so that your will controls those assets. I can't tell you how many empty trusts I have reviewed where the structure is there, but there's nothing titled in the name of the trust or designated to go to the trust after the person has passed away. So despite the fact that they've set this up and they're hoping that it's going to benefit their family at the time of the administration, nothing is going through it, or some of the stuff is, but some of it isn't. So some of it's going through probate, or, I've heard of people being told, oh, don't worry, your pour over will be able to fund your trust later. Well, then you're not avoiding probate. And that's one of the benefits of having a trust, is the ability to avoid probate. If you're relying on your will to put stuff into your trust later, then you're absolutely sending your stuff through probate. So you want to make sure, again, that you understand how what you own is impacted by the tools that you're using. So a will is a basic set of instructions to the probate court about what you want to happen with your property that you're sending through probate at the time that you've passed away. There's an opportunity to pay bills, administer your estate, sell property, liquidate things, and then notify creditors. So these are all opportunities during the will or the administration of the will. With a trust, it's another set of instructions. This time it's instructions that are left to your family and to the different financial institutions where you might have accounts. So rather than a court administering this is an administration that happens privately within your family. Your trust has a set of terms about how your property is going to be managed during your lifetime, What happens if you become incapacitated or if your spouse does? Who's in control of things, who your backup people are in terms of who's going to manage things on your behalf? And then what happens after you have passed and what happens after your spouse has passed? So it's another way to lay out a plan for your loved ones to follow to deal with your assets during different points in time. With a will only applies at death. So it only takes effect after you've passed away. You can't do some of that planning for what happens if I become incapacitated or other things happen to me during my life. With a trust, you do have the opportunity to do that. It can apply during your lifetime as well as after you've passed away, so that can be an advantage. The trust also avoids the probate process. Anything that you have going through your trust, as long as, again, you have things designated and owned correctly, you'll be able to avoid probate with the assets that are funneling through your trust to your beneficiaries. But it's another opportunity for you to say, these are my instructions. And so my, in this case, backup trustee or successor trustee is just following the plan that I have laid out. There's another opportunity to deal with creditors, to pay bills, deal with final expenses. A trust can give more readily accessible ability for the trustee to access accounts, to pay bills and things like that. Probate does come with some delays just because you're dealing with a court process and you have to have filings and things like that. So it can take a little bit longer to access funds initially. With a trust, you can allow for immediate access to be able to pay for some of these expenses. And like I said earlier, it's a process that happens privately in most cases, where it's just within a family. They might be working with an attorney, with a financial advisor, an accountant. So there might be professionals that are helping, but it's not happening in a public forum like probate does.
Yeah, one of the common concerns of people is because probate is a public process, somebody can look up the inventory of all of the assets you had when you passed away. There tends to be a preference for the trust administration after somebody dies instead, because it is not a public process. So nobody can look up, hey, what did this person own at the time that they died? What are the values? Who are the beneficiaries? Because, boy, I want to be their friend now. Anything like that. And so, if you're a more private person, you'd probably tend to lean towards trusts as your planning tool. If you're of the mind of, I'm dead, what do I care? Well, then there's nothing wrong with using a will and having it be public. So different tools address your concerns differently. And so you just need to figure out, okay, where do my priorities lie? How do I want this thing to operate? Do I want it to be private? Who do I want in control of it? For trusts, for instance, a trust, a lot of people incorrectly assume that a trust is like a type of investment or anything like that. It's really just a legal agreement about how your property is to be managed during your lifetime. And then it says where it goes upon your death. And so that's why there's no need for the probate court, because as a person, you're dying without any assets in your name. They're all within a trust that you control, so that there's no need for a probate process. And so that time and expense is no longer applicable to you. And instead, the trust administration, and you name the trustee, and trustee's the manager. Most people opt to be their own trustees during their lifetime. And then they say who they want as the trustee to manage things after they pass away. And that very often is a loved one, a child, somebody that you trust. But it also could be, if you would prefer, you can have a professional trustee administer the trust for you. So if you say, boy, I love my kids, I want to provide for them, and a trust seems appropriate, but I don't think either of them can really handle or are trustworthy enough to be a trustee. Well, you have an option for having a professional, and the professional's job is then to just follow the terms that you've put together for them.
You also have to understand that there are many different kinds of trust. There isn't sort of like one trust that everybody just uses. Just like it's not a specific type of bank account or a specific type of investment where you have to move your money to something else. You're just using that particular document to control what you have. But there are many, many different kinds of trusts, and they're set up for different purposes. You can have trusts that are just for the purpose of planning for your beneficiaries, if you want to protect what you're leaving to your kids, and like from divorce or health problems or bankruptcy or bad financial management, or things that we've talked about in some of our previous sessions. A trust it can be a good tool for that. There are types of trusts that are specific for nursing homes and long-term care. If you want to try to shelter assets because you're worried about being able to afford a long-term stay in a skilled nursing facility, or if you want to plan for care at home, there are specific trusts that do that. There are certain kinds of trusts for veterans. There are certain kinds of trusts for specific types of assets, like life insurance trusts or trusts to own cabins or other property. So there can be a lot of different types of these, and it depends on your situation as to which one is right for you. And that's really where the attorney comes in.
Yeah. One other type of trust that can be very important for people, if you're charitably inclined or you do a lot of charitable giving, there are charitable trusts that can be created, because if you're going to be leaving assets to charities, you might be leaving money on the table by not setting up a charitable trust right now. So there's a lot of different options out there. And the reason that there's a greater variety of what can be done with trusts is you can create those during your lifetime and they exist. As Sarah said a moment ago, wills only take effect after you die. So there's some more limited options. And also the fact that they're through the probate court, sometimes there's less tax planning that can be done through a will. So the point of this isn't to say wills are inherently evil. We're just trying to dispel some of the myths, because a lot of people think, oh, if I have a will that lays out the instructions, so nobody has to be in the court system, but that's not how that works. What would you say a normal time frame for the probate process might be?
It can vary quite a bit depending on what your circumstances are, but on average, probate takes about a year. It does cost money to go through the process. The court system charges based off of how much you have going through in the property and the value of the property that you have going through that process. So it does have some of those drawbacks to it. We also talked about how it's a public process. There are certain circumstances, though, where a will is either necessary or can be very useful to your family. Whichever of these two options, or whichever process you choose to use or tools you choose to use, you want to make sure that your family is getting value by what it is that you're doing. So, or if you're using a will-based plan, how is that helpful, or how does that provide value to them? So if you have minor children, you have to use a will, because that's where you nominate guardians for minor children. So the court is the only process that can name a guardian for a minor child. So you have to use a will for that process to have a voice in that process. If you have a deficit estate, so if you owe more than you have or are likely to at the end of your life, it can be very helpful for your family to be able to use the probate system and the judge to deal with creditor claims. If the creditors are not going to be fully satisfied, because there just isn't enough in the estate to pay for all of the bills, you don't necessarily want your loved ones to be telling them that. Having a judge be able to tell them that can be very useful. And then if you're going to have a significant amount of conflict, if you think there's going to be argument, or if there's going to be litigation, it can be helpful for your family to be put into a forum where that can happen, because there's a process set up for it. You have the judge, that's the referee, there's filings, there's attorneys, there's forms to use. So if you know that there's going to be fighting, it can be helpful to put them into the court system where that can happen and get resolved. Mm-hmm. So those are
and one other option that's very helpful when it comes to wills is if you have a spouse who's in the nursing home or going to be in the nursing home, and you're concerned that, boy, if I pass away first and I leave everything to my spouse, it's going to get eaten up by those nursing home costs. There's some planning that can be done through wills to help protect some of those assets as well. So, there's a lot of different options and a lot of different tools out there. But as Sarah was saying, if you create a tool, you have to use it, or else you wasted your time creating the thing. So again, creating a will and then putting beneficiary designations on everything means your will ended up being a waste of time and money and everything else. And having everything go by beneficiary designations is wrought with its own group of problems, where Where is the money coming from to pay for the funeral or pay for last expenses or maintain the real estate before that gets sold? And we can go on and on about different issues that get created by these beneficiary designations, because they sound like a simple fix, but then they can have problems after the fact that aren't capable of being repaired. So that's some basics on how wills operate and how trusts operate. We're going to turn our attention to a couple of questions that we've received here. One of the questions is, what can the power of attorney do for the checking? So I assume they mean a checking account, and what the power of attorney can do if there's a checking account is whatever the power of attorney document says they can do, which I know is one of those sort of lawyerly, it depends kind of answers. But basically, the person who's acting as the power of attorney, it depends on the powers they've been given. They have a fiduciary duty under all circumstances to act in the best interests of the person who is disabled or owns the property. So what they can do generally is, pay bills, manage the account, but then different powers of attorney documents vary wildly. And one big problem that we run into is a lot of people think, oh, I'm on the power of attorney on like the bank form at the, say, US Bank or wherever. So I can just do whatever as power of attorney, right? And the answer is no, not at all. You can only do the things that you are allowed to do by the documents. And I can tell you, a bank form is not going to provide any ability to do things like long-term care planning in an emergency. So if you're power of attorney on a bank form and your parent goes into the nursing home and because they've lost capacity and aren't able to do things for themselves, and you're thinking, boy, I want to try and protect some assets from nursing home costs, and I can do that because I'm the power of attorney, right? No, you can't, because the bank form does not provide the power for you to do that.
You also don't want to have a general grant of authority with that. You don't want to say, well, they have all authorities concerning my bank accounts and that'll take care of everything. What the bank wants is a specific list of what exactly they're allowed to do. And that's true when it comes to all of the different financial institutions. You have to be very specific in that kind of thing.
Yeah. So next question for you. Why in the heck is a will called a pour-over will?
We were talking about how there are different kinds of trusts out there and that people can use them for different purposes. There are also different kinds of wills. There's not nearly the variety that there is with trusts. With trusts, you can even have more than one trust. But with a will, you're only ever going to have one will. It's one document that controls,
or at least one at a time.
One at a time. That's true. One at a time. A pour-over will is often used with a trust-based plan, because you want to have kind of a catch-all to make sure, if I'm 95 and I go open a new bank account down the road and I don't remember to put the name of my trust on the account and I use my own name, I still want everything to get back into my trust, even if it's in my name. So a pour-over will pour your probate estate into your trust after you've passed away, if there's anything that you still own in your name at that time. Like I said earlier, you don't want to rely on that kind of a document to put things into your trust, because you're using the probate process to do so. And one of the advantages of a trust-based plan is the ability to avoid probate with things that are funneling through the trust. So your pour-over will pours your estate into your trust, but ideally
through the probate process.
Through the probate process, which ideally your family is able to avoid by the fact that you have a trust at all. But it is a good backup or contingency plan.
Yeah. So I'm aware of different, information out there on the internet. If you have a pour-over will, that's so smart because that'll help avoid probate and get the assets into your trust. No, that's not how they work. Probate, pour-over will is a set of instructions of the probate court like any other kind of will.
It's still probate.
Yep. Okay. And then another question is, our home is only owned in my husband's name, and he owned it before we got married. Is this something we should make sure is in both of our names right away? Maybe.
Another typical lawyer answer,
yeah,
unfortunately.
There are way too many facts that need to get uncovered in order to be able to give an answer on that. It could be the husband's intention that he's trying to maintain it as individual property and not marital property, because if you commingle it, putting both names on there, then you're looking at it being joint property, and he's perhaps, inclined to keep it as individual property to avoid division if, God forbid you guys were to get divorced later or anything like that.
There could also be problems though if you're using joint assets to maintain the property and you don't have your name on it. So I mean, I think this is something where you need to make sure that you both understand what your intentions are with this type of an asset. Where is it that it's supposed to go if something happens to one of you? There's also tax planning that can happen that you might not be taking advantage of that you could do if you had titled this differently or were using a different method to do this. You also want to make sure with blended families, especially if either of you have children that you do not share with your current spouse, there are a lot of very surprising things that happen if the parent passes, leaving a surviving spouse, but there are children that are not the biological children of the surviving spouse. There's a lot of things that the children are now all entitled to, even if the spouse survives. So your estate isn't just automatically going to your spouse, that you end up in situations where you're identifying what's subject to division, what are the kids getting right away, and there can be a lot of very surprising things that happen. I've been involved in a few different administrations where unfortunately we didn't have an opportunity to do any planning, but we were brought in to try to help figure it out after the fact. And it's always hard on the people participating to figure out what was the intention.
It's complicated, and the timing of acquisition of assets and everything else ends up playing into it. So potentially, if the intent, if he were to pass away, is to pass it solely to you and avoid the probate process in the meantime, maybe joint ownership on the house is an appropriate idea. But again, that's something that all of the different facts need to be known before you can really get any advice on whether or not it's appropriate to just co-own the house. Okay, so we've hit our time limit. Hopefully you guys found this a useful exercise. If anything that we talked about sort of raises a red flag or is something that you feel you need to dive into deeper about your own particular circumstances, please feel free to reach out to our office. We have complimentary initial consultations that usually last a couple of hours, and we can dig into your particular circumstances and what we might suggest in your estate plan. So without further ado, next Wednesday is our next class. Do you recall the topic for next Wednesday?
No.
I don't either. We'll leave it as a cliffhanger, I guess.
Farm planning. It is farm planning. How to plan appropriately for either farms, passing on farms, or just even inheriting property that is, you're renting out right now or that you may inherit. And then
long-term care with farms.
Long-term care with farms.
Farms are a whole beast unto itself.
It is its own area of planning. And then for the month of July, we're doing maintaining independence in a variety of different ways. So the entire month of July, our webinar sessions are dedicated to the theme of maintaining independence through your estate plan. So hopefully we'll have some pretty good topics for you there too. But we've been able to, I think, get through all of our material today and answer the questions that people had submitted. So we're happy about that. Check out our website if you want to follow up on any of these topics and are looking for more information.
Yeah, we should have mentioned that. We have a lot of information on the website about the topic that we just covered today: wills and how they work, trusts and how they work. So
and we recently added some additional information as well.
Yeah, quite a bit. So hopefully you find that a useful resource also. And estateplanningseminar.net is the way to sign up for the
next session.
Yep, the next session. So thanks for your time, everybody. Hope you found it useful. Now go enjoy some of the nice weather we're having today.
Bye, everyone.